So in my last video, we talked about the process that happens from the time you're involved in your injury action until the time of settlement and prior to the lawsuit. But you might be asking yourselves, what happens if the case doesn't settle? So what I wanted to go through here is the general process of litigation from the time that the lawsuit is actually filed officially until trial or settlement before that. So generally, what will happen is when a case is ready to actually be sued, what will happen is the attorney will draft what's called a summons and complaint, which basically outlines in general form the allegations in the case and the basic facts about what happened. Now, if it's an action that happened in state court, you can be more general in your pleadings and in your complaint. However, if it's a federal case in federal court, you have to be a lot more clear and specific regarding what your factual allegations are. And once a complaint is filed, it'll be served on the defendant, which will then likely provide it to their insurance company, who will then have an attorney answer on the defendant's behalf. Once the attorney receives the paperwork, they'll file a formal answer basically denying everything that is present in the complaint, aside from facts that are not disputed. And also send along discovery demands, which will basically be asking for medical records and a document called a bill of particulars, which basically asks for a further particularization and specification of what your claims are and what your injured body parts were as a result of the accident. Generally, the information that they're looking for are photos, videos, medical records, authorizations that will give them access to all of your information. And what the attorney will do at that point is provide all of that information, draft the bill of particulars, go over it with the client, have them sign it, verify it, make sure that it's correct. And then once that happens, they will file it and also send along discovery requests that they're going to be making to the defendant. Once that is exchanged and all of the responses are had, the attorneys in most cases will schedule party depositions. That is basically a question and answer under oath of the parties involved regarding how the accident happened, what the injuries were, and what the allegations were. Depending on how many witnesses there were, there may be what's called non-party depositions, which is when non-parties to the lawsuit who witnessed it are questioned under oath about how the accident happened. Basically, what comes out of that is a transcript of every question and answer that almost gives a preview of what a person would say at trial. Now, after the deposition phase, sometimes there's follow-up paper discovery, sometimes there's more depositions that are done. And usually at that point, once all the discovery is done, one of the attorneys will file what's called a note of issue. And a note of issue is a document that basically tells the court, hey, we're done with discovery here. And once that happens, a lot of the times a plaintiff or a defendant attorney will make motions to either have a case dismissed or have a case found in their favor or any other sort of a motion. After the motion phase, assuming that a plaintiff overcomes any motions to dismiss, the case will be scheduled for trial. A trial date will happen, the trial will happen, and depending upon the result, there could be a possible appeal. So in short, the litigation process is long. It's a very drawn-out process, and it could take years. So this is just to give you a general idea of how things have happened from my experiences. So I hope this was helpful.